stakeholders. We directly correspond with the stakeholders. To identify their problem statement is the most important aspect of my business here. So when I'm talking to them, I understand this is our problem statements. Let me figure out.
Hello and welcome to the Super Lawyer YouTube channel. We are delighted to welcome Mr. Abhinav Kumar Karn sir today. With over a decade of experience, sir has earned a stellar reputation through his work with esteemed institutions such as JP Morgan Chase and the Standard Chartered Global Business Support Team, showcasing his profound legal expertise in navigating complex corporate landscapes. Also, as the founder and managing partner at the Contracts Consultants, he specializes in contract drafting and negotiation, privacy and data protection, corporate governance, e commerce law, and cross border transactions. Thank you for joining us today, sir, and we are eagerly looking forward to gaining valuable insights from your experiences. My name is Anshi, and I work as an associate with the Super Lawyer team. I'd like to introduce you to Divya ma'am. Divya Dwivedi ma'am is our team lead at Super Lawyers. She has extensive expertise in legal and technological matters, including AI, ethics, privacy compliance, IPR technology, and other related fields. She also practices at the Supreme Court of India and offers valuable insights into complex legal and technological issues. Thank you for being with us today, and I'd request Divya ma'am now to please continue with the conversation. Thank you so much.
Thank you, Anshi, for the introduction. Thank you, Abhinav Kumar sir, for being here and
Thank you.
giving us an opportunity to interview you. We here today are at Super Lawyer YouTube channel introducing the contract consultant. He started this with an idea of talking about contracts all over. That's what my assumption is. I will request sir to go ahead and introduce his concept of starting this specific consultant group. What was the thought process behind it, and why did you choose this name?
Hello, everyone. Thank you, Anshi, for your lovely introduction. Thank you, Divya. First of all, I really like to specify as to why I chose this name. In the era of great legal valued names and law firms, legendary law firm names, right? I chose something which was beyond the track, the contract consultants. Why is because I always felt while I worked throughout my career that contracts is the heart and soul of any business, and we look after the contracts, right? We work towards the contract. So if your contracts are drafted nicely to your understandings, then how does it save you? It saves you from a lot of legal expenses, your arbitrations, your mediations, your compliance aspects. So any business who want to excel in their career, I think contracts are the ones which they should be paying attention to. So that's where we came to this name, contract consultants, because that's kind of the place where our expertise lies. And we felt that this is something that we want to do. You grow and we help with your contracts. So leave the contracts and the documentation to us while your business grows. So that was basically our idea why we kind of accumulated this name and came forward with this name.
Very nice idea, and thank you for answering that. Usually, we start with the question of why did you choose law, when did you choose law, what all goes on. So now I'll come back to that, and I'll try and understand what kind of challenges did you face while you chose law, because there are certain times when we are questioned of our choices. So first, we'll request you to answer that, and then how has it changed the course of your life? Because you have been practicing law now for well over 12 years. So what kind of experience have you manifested over time?
Goes back a long time. I think it would be a personal story altogether, but then I would just cut it short. So basically, I belong from Ranchi originally. My house was right beside the High Court. From the very childhood, used to fascinate me how people used to dress up, flaunt their black coats, and then enter into the premises of court. Right. So all those things definitely kind of made me feel that this is an awesome profession. But again, back at our place, law was not taken to that level. It was not considered to be of that level. It's always kind of considered as a very low level job when people fail in their life and then to take that up. So the challenge that I faced, first of all, to pursue that was that in whole of my family, my relatives, everyone, that was kind of a peculiar decision that I wanted to take. While my whole family has a background into science, my brother is a major in Indian Army. So, all those kind of things always impacted me. But yeah, my father stood by me. He told me that definitely you take ahead. So the first challenge was to win over my family to pursue law. So that kind of gave me a success. gave me a feeling that definitely this is something that I want to do. Post when I joined law, I had an amazing feeling that it throws such an amazing plethora of options towards you. Again, when we started pursuing law, the only thing that came to your mind was either you become a judge, appear in judiciary examinations, or you start your own practice. But with the evolving future of law and the current scenario, I think there's an amazing push towards pursuing of law. There's so many law colleges, upcoming law colleges that have started this. So all those were challenges at the very start of my career. These things are, it seems or it sounds very easy, but to convince, to take a decision in your life when you think that maybe you would be cornered in the whole of your family, in your circle, if you take something of that sort. To choose law was something which was daring from my aspect, and it turned out to be amazing when I joined. So I've done my law from MS Ramia College of Law. You know, sitting there, meeting people from different cultures, understanding the value of education, moving from a small tier city to city like Bangalore, it creates an amazing impact on your brain, on your character, of how you look forward to building your life and career. So those were the challenges that I was facing. And when I came across that, I think you start developing as a person. So I would say challenges were definitely there, but all those challenges have molded me to what I am today, taking tough decisions, thinking about a life which could be beyond your small city living. So, yes, it was an amazing, I would say, decision that I've taken in my life of pursuing law. I am enjoying it. I started with litigation and then shifted to corporate. So, kind of have the feeling of what litigation has in store for you, what corporate does. And then with all those mixed experience, I had that feeling that now maybe what I always wanted to do was make a name of my own, make a impact on the society. So all those things kept playing in my mind, and then I decided that let's start something of our own and serve the society. And also, definitely, it's just not about serving society, it's also about standing in your own eyes, how you treat yourself, what you consider yourself to be as a person, and whether you are a successful lawyer. Successful can be defined in different ways, right? For me, it is something that you stand for yourself. Again, commercial aspects are different, but when you talk about yourself, you should be sure of what you want to do in your life. And I would say a lot of people figure out at a very early stage. A lot of people figure out at a later stage of their career, later stage of their life. For me, what I discovered was it was gradual, slowly and steadily. Every single year that went by, I kind of figured out that this is what I want to do. It just strengthened my thoughts inside that this is where I want to push my career. This is what I want to do. So, yeah, I mean, that's the basic crux of it, how I landed up with law.
Beautifully put. No one usually likes to talk about how family can say that, okay, you are cornered now. But it had its own challenges, and but then you overcame that. Now, coming back again to the contracts and e-commerce contracts, especially where your experience lies and your expertise is, what are the most common pitfalls that you may have seen while working with companies, corporates, and doing litigation as well, while drafting their terms of services or privacy policies or anything related to data? How have you helped them address this particular challenge or issue which arises with maybe any kind of contract that may go wrong? How have you made sure that they have that successful contract drafting?
See, my way of working goes with the self understanding of what and how. So, whatever comes, if you're a lawyer, I would say what and how are two very important words in your life. So, when it comes to e commerce or any for that matter, any business, right? Today's world is excelling in every field. People want to do their own business, everyone wants their own startup. Right? So, that's the biggest thing that is going on. Talk of the town is that. And when you enter into this kind of services, end to end customer, B2C, B2B, where people fail is that they don't see what kind of challenges would they be facing if they enter into the business without even considering that if you just merely go ahead, copy your terms and conditions, your privacy policies from already existing websites. What you need to understand is what is your business and how is the business running. In e-commerce, there are segregation. There's an intermediary, there's a business to customer, end customer. So you need to first of all categorize it of which business are you into. It's an e-commerce platform wherein it's a marketplace for a lot of people. So then you decide as to what would be the terms or what would be the privacy policies that you need to adhere to. And there have been several aspects of it. People miss out the dispute resolutions because it's customer facing websites that they have. People don't put a check on the liability. How exactly will they deal with liabilities when it comes to such scenarios? When you talk about terms and conditions of e-commerce, there are other aspects to look into, like how exactly is the user interface? How do people shop there? What would be the end liability? Who would be the person who would be responsible for it? Whether you are in compliance with IT rules and regulations that is applied in India, whether you are complying to Consumer Protection Act, whether there is a funding from foreign direct investments, there is a ban onto that as per the rules and regulations, whether there is GST applicable. So many nuances to look into. There's not just one. And if you look at the very basics of it, boilerplate clauses are everywhere. AI can do that for you right now. But then you need that strategic approach of how to exactly safeguard the end customers. End of the day, we are business enablers and we want to do that. So to figure out what is the business, how do you function, and how do you cater to the needs of the end customers, who are your end clients, you come up with your privacy policies, you come up with your terms and conditions. It seems very standard because it's visible on your televisions, on ads, on your daily marketing stuff. But when you look into the detailed versions of it, you need to connect to the exact soul of that business, and that's how you draft it. So these are the basic ways of how you look into the terms and conditions or privacy policies, or even the other aspects or compliance, I would say, when it comes to e-commerce, because these days Indian government, specifically talking about India, Indian government is very particular about compliance aspects or what e-commerce platform needs to follow. So all these things definitely come into picture, and you need to be very attentive towards that.
Great. So you call yourself business enablers,
Yeah.
especially when you're talking about this, while enabling all these aspects for businesses. There are negotiations also that take place that you have mastered over the years. Along with that, over past decade, there have been a lot of changes, and that too rapid changes in technology and the kind of digital transformation that we have gone through. How have you molded your approach towards the risk management in those specific kind of contracts which have changed over the years, and the kind of negotiation tactics that you may have applied or may have garnered over the years, understanding this is how we can negotiate or term our policies so that it can be easy for businesses to get enabled with your help?
When I specifically talk about the kind of changes that has happened in the last decade, it's huge. The impact is also very huge. More or so towards the use of AI, artificial intelligence that we speak about, or the confidentiality of data, data breach. Initially, sign an NDA and you're done with your confidentiality safeguarding methods. And there was a small clause of confidentiality in your contracts and you're done. And people used to interpret it in that way that it covers everything, everything should fall into the ambit of confidentiality. But given the time, development, and the changes that have happened, they very specifically call out those changes. When you look into the data privacy, it's a new world out there. When you do cross-border transactions, again, you need to be very specific. With the advent of DPDPA now in India, definitely India is also on the verge of doing that. People are getting very aware of how and what exactly. Many businesses are susceptible, they're skeptical over how exactly we should deal with it. So what changes have we brought in ourselves is because we have seen the changes, gradual changes, every step by step. When I started, it was NDAs, confidentiality. Among the mid-career, we elaborated the definitions of confidential information. We started putting or quoting data. Now you're defining data. You're defining data breach. You're defining data transfers. You're defining that if something goes wrong while using AI algos, who would be the liable person? So you're clearly calling out so many changes within your contract. And then you also call out the amendments. Previously, amendments was only for the purpose of scope of work, term extension. Now you leave a plethora of options open for amendments purely to incorporate the legal and regulatory changes that you want to bring about. Because no one, me or you, entering into the contract, we would not want a regulatory notice to come to us. If an information of such changes is coming to us, we should be well equipped of how to bring about the changes in your main contract. You sign an MSA, you bring about the changes. So amendments has also not been just reduced to purely signing your basic term extension, your scope of work or commercial upgradation. It has gone beyond that. You keep the options open. So with the advent of technology, there are a lot of things that has been added. it eases your work also. And because I have also done, on my team has also worked on cross-border transactions, we see how there it is impacting. So all these things, the changes that have happened with the advent of technology, with the advent of contract development, these things have to be taken care of. You are more aware now how to bring about the changes. So I would say the risk aspects of a contract has increased, but also given the lawyers the freedom to put their inputs there. With AI being there, you need the circumstantial understanding of the situation, risk analysis. You go to AI, they will tell you how to generate a contract, but they will not give the human touch there. They will not understand the business aspects. They cannot hear out the stakeholders' problems. So all these things work like that, and that's how we have also developed.
Absolutely amazing that you at least gave the clarity about all of it. We would like to know more about the way you go ahead with the master service agreements that you develop for especially technology companies, and you have been working on that. What kind of provisions do you often put in your contracts that you draft through your company and through your firm and while you're working as their legal counsel? Have you seen things that have been overlooked? Maybe by default, it happens that they just overlook that this is going to be there, but they miss out. But it may affect their long term interests and sometimes short term interests as well. So, how do you make sure that that does not happen when you are drafting it? And how do you make sure that even if it has happened before you were hired, to make sure that their interests are being taken care of?
So many umpteen examples for that. What happens is boilerplate clauses are very evident. Now, when I say boilerplate clauses, obviously for the layman here, it's like the simple contractual language clauses, indemnity, liability, terminations, your effective date, and so on and so forth, your jurisdiction, your governing law. What people miss, or I would just keep an example there, if a fresher comes into a role, he has been hearing, he has been interning, he has been looking at the documents, he has been overwhelmed with the kind of document that he's looking into. He's concentrating towards those legal aspects of the contracts. What he may miss is a small line which says auto renewal. Now, auto renewal is fine, but the thing is that you don't write an auto renewal, or generally what I suggest is you don't let it be there. At least let both parties know about it. Renewal should be there, but it should be with the conversation, with the mutual agreement between both the parties. So you just leave auto renewal like that, and then you suddenly realize down the line when you are thinking about that, okay, now 1 year term is about to be finished. I know that I have got a very attractive offer from a newcomer in the market, and I can save maybe millions. And then suddenly you miss out on auto renewal clause of the old existing agreement, and then it automatically renews. And then you are like caught in a spot of bother. You're like, okay, I've absolutely missed that. Now you are bound to continue for another year. Very small, very petty matter to be looked into. A lot of people would disagree, but to enable the business to save money, that is what our job is. I'm giving you a holistic review. I'm not just restricting my review to only your legal aspects of the agreement. I'm looking into your commercials. I'm looking into the smallest of additions which could change the whole complexity of the document on your commercial aspects. So all these things need to be paid attention to. You're working with so many other customers. Your confidential information is at stake. Your trade secrets is at stake. You don't realize that. I am not naming anyone or telling or defaming anyone that the other party would be doing that. But then that's what happens. Why do you sign a contract? To mitigate your risks. This is one of the risks. It can and it does put you in a spot of bother. So very simple things will always make you worry at the later stage of it. So while you're looking into a technology aspect contract, the scope of work, initially you start with one, you don't define it properly, and then it keeps on adding to you. Now you signed with a 1 lakh contract, and later on you end up doing 2 lakh of work. So scope of work is very important. Termination, as I pointed out, is very important. So there are different ways of looking at it. So all those things definitely work out. So you need to be very particular of how exactly you want to do that. So yeah, that's one aspect of doing it. I mean, I could come up with several other pointers, but again.
We understand that more than a decade of experience gives you a lot of things to talk about. But you started off with a very basic example, and that is the beauty of this explanation. That is why I would again ask you to explain the same thing in relation to the compliance work that you do, that your company also does. You have been heavily involved in the businesses where you balance their regulatory requirements with operational efficiency. But my question here is, in the kind of new market that we are expanding and working, how have you made sure that you give them the same level of clarity, basic understanding, and safety that is required, that particular safety net that you provide with your contract drafting? How have you done that in this new era as well?
And I'll just go back to my first comment when I said the two basic words that help me out wherever I want to work in a professional way is what and how. So when you talk about compliances also, what are the changes? What are the upgrades? What are the compliant related laws and regulations? How do you enact them? How do you enable your end customer to enact them and fall under the purview of it? So that's the basic way of looking at any compliance aspect that you want to comply to. And how do I look into that? Once these two things are figured out, you speak to your stakeholders, these two things are figured out, what and how. Then you make a list of it. How do you help them to enact it? Is that, you make a comparative table. What is already there? What is existing? What has come new? You make the comparison. You think what is the changes to be done? The gap analysis, the risk analysis has to be done. You mark out the important ones. How I work is you say red, amber, green. You identify the red, then you go to amber, then you go to the green ones. There could be changes in green ones also, maybe a repetitive change, maybe an addition, maybe a word tweak. So everything needs a change and upgradation. So that's how we work. We try and focus on the problem statement and develop a roadmap, and then we move forward slowly and steadily. We always tell this to our end clients that once you've given this to us, we want someone whom we can approach always, because you're in a constant learning phase. I am not doing the business, the end customer is. To learn the business is of utmost importance. Once you learn the business, then you start your research. Then you understand what compliance could there be, what possibilities are there. New markets are coming up everywhere. New markets could be a new business, it could be a new jurisdiction altogether. So you need to very specifically specify that, segregate that, and then work towards the upliftment of it.
Amazing. I'll go back to the previous question where we were talking about very basic examples that you gave. As at Super Lawyers, Abhinav, we talk more in terms of helping people understand whom they can reach out, how and what their perspective before choosing any specialization should be. Like contracts is the very basic of everything that we do in law. What would be your maybe nuggets that you have followed, the kind of pointers or checklist maybe you have decided? And how will you explain this to the new entrants, that where is that particular integration point of contracts, commercial contracts, contract resolution, dispute resolution, and how in litigation all these ADR methods have helped you and is helping legal fraternity as well to ease on the fashion of business? Because if ADRs are not there, it'll become a very big litigation process. So how have they evolved over the years? What kind of thought process should be there while you are drafting those kind of contracts where these pointers are there? We would request you to share that because you have been working towards it for well over a decade now.
Yeah. With all the limited experience that I have, I would definitely like to answer that question. Now, what I've figured out is that since I work for law firms and corporates both, one pain point, I would say, or not pain point, I mean, it's a different perspective. Different people would have their own opinions, right? But what I figured out was when you reach out to a law firm, supposedly, for a drafting of a template contracts that would run your business across, the language that is used is heavily loaded. For a common layman, impossible to understand. That is the biggest problem statement that I figured out. How do I work on that? Because I know that while I joined a company at the very nascent stage of my career, for me it was difficult. People could question my vocabulary maybe at that particular time. But then seeing the funny part of it, the originality is that it's heavily loaded, legal jargons are everywhere. You are unaware of the fact small, medium enterprises, businesses, startups, they just don't go to a creamy layer of lawyers and they hire them. They would like to go for people who have just freshly passed out, help them. That kind of work passion comes into them. They fail to understand so many aspects of law there because of these heavily drafts. When it comes to you, and supposedly now you are negotiating the same aspect with the other client, it gets difficult. It gets tough. So how we have come across this understanding is that we try and keep the draft in the most simplest of ways. If I draft it, if you are a well-educated person, you should be able to understand at least 80% of the contracts. Yes, I cannot change the legal words that is being used, but then I can draft them in a way that you at least will have a sense of understanding of what exactly the TCC have accumulated and come up with. So that is the major thing that I always felt that is a problem statement. Anyone should definitely look at a way that you draft the clauses in such a way that it is very understandable to the end person who is using it or who is reading it. Stakeholders. We directly correspond with the stakeholders. To identify the problem statement is the most important aspect of my business here. So when I'm talking to them, I understand these are problem statements. Let me figure out a way. How do you figure out a way? You draft those agreements. You write it very clearly. You call them out very clearly so that even if you're not there at a given juncture, they would be smart enough to deal with it. Yes, at a point of time, you need the intervention of a lawyer or a qualified counsel. But the first aspects of negotiation can always be done by the business also. I'm not eating up anyone's money here. I'm just telling that this is the way we work because we are not that kind of people, or I would say professionals, who would draft in such a way that you keep coming back every now and then to us and we keep charging you for every hour. So our basic funda here is to make a template to draft in such a way that people understand. Moving beyond that, I think I digressed a lot over just one topic, right? But moving beyond that is to frame the contract in such a way that the person in front is understanding, and when he moves out with that contract to anyone, when he's pitching that services to the end customer, because always what happens is you need a handy agreement with you. In given today's fast flying time, you speak to me and then you are like, okay, share me your templates. You should have it handy. How do you do that? You do that by having a well drafted template already with you. And that well drafted template would be covering almost most of the aspects of your business, but definitely not your trade secrets. So those are the aspects which I think and which our team has always felt that should be the problem statement that we work. Our whole management decision varies on that as to how exactly to frame those clauses and put into the contract so that it is an ease of reference for anyone.
Keeping all that in mind, the way TCC is evolving and the way over these many years you have understood the concept of being in a law firm as well as in litigation and then moving on and working towards your own firm, what kind of dispute resolution issues have you come up? Especially keeping the commercial contracts in mind. And nowadays, this IPR dispute resolution also is coming up, ADR for IP. Have you come across any such issue that may have been taken care with a properly formulated contract? It may not have developed into a dispute. If just let's say a couple of lines were there, or maybe even a word, like you said, auto renewal becomes an issue.
Oh, yeah.
Was there any such experience for you?
Yeah. As we are talking about contracts, it all kind of boils down to the language of the contract that is there, right? People definitely want to refute that. They get into the correspondence. Now, what happens is, first of all, I would take forward this that any dispute redressal, how do you actually work on it? Three, four things which matters to anyone is that how much of money saving is done there? How much economical is it for the parties to do it? If I get into a dispute resolution, with whom am I getting into the dispute resolution? Is it a long lasting client that I have? Is it worth enough to get into a dispute of maybe 1 million and then to cost me 5 million? And then ultimately, because we have got into that dispute, I am risking the goodwill that we've already made it with them. So being a lawyer, I just don't resolve disputes. I also put my legal and business acumen into resolving of the disputes. It's not just giving you a dispute resolution by going to the court, setting in an arbitration and drafting a resolution for you. I'm a business enabler, as I told you, and I would be very profound in calling out these things. I am getting my money. You come to me, I say, done. I'm drafting it. No worries. I'll send out an arbitration letter or whatever it is, right? The first steps that needs to be taken to. How are we different is we call it out. We tell them, right, this is not required. Let's get on a call. Let's sit down. Let's discuss. How are we going to move out of this dispute? What are the results? Is it a result driven dispute? Is it fetching you enough amount there? So all these aspects are definitely to be considered. So when you work for disputes, these are something that you need to take care of. Now, evaluating the situation is very important. So all those things have been taken care of while we work for dispute resolution. Coming for IP, see, IP was always a part of disputes. People have been very vocal in their contracts, calling out what would be their IPs, what would be your IPs. If together two software companies are working, both of them are working together. Now they are working hard to come up with a product. Both of them can have a tussle over the same product. Who will own how much of IP rights? To formulate the language in such a way that it kind of seizes the battle and figures out a way that both of them benefit is something which is very important. So disputes with relation to IP will only happen when it's a huge amount involved or if a company's future is involved. Like I told you, you're letting the other person audit your whole system and then one of those aspects just backfires you and then your trade secrets gets exposed. Disputes of such level also have happened. So it's all interrelated how you look into the dispute resolution methods. The language has to be very precise, calling out, and also in a detailed way. What do you want? Where do you want? How do you want the dispute to be resolved? Who all would be involved in that? So all these things have to be taken note of. So dispute resolution is something that you need to be focusing on while to understand the business of the dispute. And that is something which we focus on, and that's how we plan our roadmap when dispute comes our way.
The kind of answer that you just gave, we can also try and understand this aspect of the new entrants in the field of regulation, especially that is related to data protection and privacy, especially.
Yeah.
With the DPDP Act and everything in action nationally and internationally, there are several others, especially and alongside there are AI Act, EU AI Act, and then others are also coming up with AI bills and everything. Everything is manifesting towards cybersecurity, AI, data privacy, privacy protection, and other aspects. All of that has to be there compiled in any contract or any form of contract. How do you make sure that all of this is encompassing and it is also helping maintain businesses their flexibility as well? Because there has to be a breathing room with all of these regulations, all of these contracts in place, as you said earlier.
Absolutely.
And now,
Yeah.
how do you give that breathing space to businesses to allow their flexibility and allow them to work as they used to work with all of the compliance, all of this in a contract, but giving them space?
There are very basic way of doing these things. At the very start of our meeting, I called it out how we work on the aspects of amendments also these days, how things have changed. So all these things are very important. You look out the data privacy. How do you work into data privacy? What are the changes you look into that? So when you're looking specifically at the data privacy changes, or you say global transaction level data transfers that is happening, if you are involved in a cross-border data transfers, you need to adhere to certain aspects of it. There are certain more regulations added to it. How do we work? Is that first of all, you need to figure out different aspects of data privacy also. Who is a data controller? Who is a data processor here? Subject matter is what? Who all are involved? What are the consents given? What kind of services are we looking into? Are there two independent data controllers? So many things to look at. Once you figure out that, you would start building a story as to what would be applicable, what would not be applicable. When it comes to data transfers, what should be applicable, what should not be applicable, what has to be put in there, what not. So you prepare your draft in such a way that at least what you have at hand and in hand, and you know that this is the template that has been globally followed, also you incorporate those. And then you keep a window open. You keep the window open, you say that any changes, any regulatory changes, brought about the government or the regulatory authorities will be applicable. It's a very narrow way of doing it. You don't have much to do there. It's just about the phrase of language that you use. How do you exactly portray it? You give the business that freedom, because it's quite known globally that any changes that has to be brought, it has to be complied to. There's no way out of it. So if you're looking at such changes, if regulatory authority is bringing that changes, you fall under that domain, you need to comply to that. So your language always prevents you doing that. If you think there's something else to it, you can obviously put a disclaimer. I would not say disclaimer, you can always put a sentence which specifically calls out that, as I told you, that any regulatory changes brought about by the regulatory authorities or the law in concern, the jurisdiction, definitely will be applicable here. Now, what happens is sometimes people only use applicable laws. That differs in a lot of places, is because few of the enactments very clearly call out that your agreement, your contract, your documentations should clearly call out that these are the acts that has to be followed. So it's again important aspect of looking, because these enactments very clearly call out that their names should be used in the document. So these are important aspects that you need to look into. And definitely it's quite common nowadays everywhere. People are looking into the data privacy, the global changes that is happening, cross-border data transfers. It's all about looking at the applicability and understanding the business or understanding the scope of services that is being discussed. Once you understand that, what is the applicability there, what is applicable, you can easily figure out and then you can move ahead with it. Right? So that's how we basically work. It's all interlinked.
Thank you for elaborating that. We would also like to continue with asking you, how do you keep yourself updated with all of the kind of changes that are happening nationally, internationally? And is there a checklist that you have prepared? Okay, this much I have to do in a day, read this and that. Because all of these resources, our learners are also always curious to understand, as in where to go to, what to read, what to skip, because you just can have so much so in your brain to process. So how do you process the whole information, work on your business, and keep your mind calm as well?
This is a habit that develops at the very start of your career, or possibly I would suggest everyone to do that. At least it works for me. I sit down at the end of every week. I have a small checklist. I don't have a very detailed checklist, but I have a kind of small checklist, pointers to be looked into, maybe a refresher session for my own self of certain things which I feel that is continuously evolving. So these are something which is very important. I would definitely come with a checklist very soon on my LinkedIn profile also. People can definitely look there to just to refer that. But apart from that, the webinars, the newsletters, subscriptions, your followers, or possibly you're following people, influential people in your own domain. So many people come up with so many informations on the legal platforms these days, LinkedIn being one of them. So to keep yourself updated, first of all, you need to be interested in doing that. It's not a hard and fast rule that you have to be. Different people have different approach, but for me, I want to be at that juncture where if someone comes up with a question about a burning topic, at least I should be able to give him some answers to it, not just throwing a dart in the air. It should be something substantial. And to make that happen, I have to be very aware of my surroundings, specifically when it comes to legal aspects and law. So yeah, there are checklists. I am subscribed to a lot of newsletters, these legal websites, and your daily conversation, even with your colleagues, would help in that.
We'll look forward to having that checklist on LinkedIn, possibly on all your social media accounts, because obviously one should always understand how other person is perceiving this whole idea of collecting knowledge and intelligence from everywhere possible. So I also want to ask you about a very important topic or aspect of our lives. That's how do we behave or work in corporate culture in order to make sure that we have a very nice work-life balance, as well as we have the colleagues who are happy with us and who are open to us to explain that we are in an amazing culture working with you or on the floor, because there are many a times when we have been told that the timing is not easy, we have a lot of pressure. So how have you gone through this whole phase? How have you made sure that you have had a work-life balance? And what do you propose that the people should follow in order to make sure that they are having the best time of their life while they are working and being at home?
First thing is definitely you should love your work. So many people they've spoken about this. A lot of people even think not possible. I'm here only to earn money. But see, at the end of the day, what matters is how invested are you in your work. That is definitely there. And there are different ways of doing it. When you enter into a corporate culture, your manager's attitude, the way they handle you, these things matter a lot more than the company. Completely a personal view. More than the company, your reporting manager matters a lot in your career. How they mentor you, and it applies to everyone from the very fresher to a person who is maybe reporting to a GC or a GC who's reporting to the managing director. How they treat you, how they mentor you, how they mold you into a person, or how they want you to function within their team. Very important aspects of a corporate culture. I'm still in connect with so many of my mentors who have been there involved in my life, taught me the way to work, also to look at life in a different perspective. So yeah, you come across different character people, and that's not the end of the world. Take care of yourself, take care of your mental health, because that is what matters at the end of the day. You're strong mentally, you will be getting physically fit. Right? So yeah, thank you, Divya, for putting forward that question actually.
Thank you so much for answering it so easily and calmly, because many a times we get that these are the checklists we follow, but you were too candid to tell us that okay, you did not have a checklist. You also went through so many things we go through, but we do not talk, and we are not that open to talking about it. But I guess it's right time to start with it. Thank you so much for being so open about explaining all these aspects, because it's not easy to explain contracts to a person who is learning contract and thinks that we have understood everything. So thanks for that. Another aspect I would thank you for is to explain to us how have you intersected contract, dispute resolution, commercial contracts, and everything. It has been an amazing conversation with you, Abhinav. Thank you so much for carving out this much time for Superlaw interview. Hope you enjoyed the session, and we'll soon be back with another session with another amazing personality. Today, we are thankful to Abhinav Karn for being here and for being with us and explaining us all about TCC and all about contracts. Thank you so much.
Thank you so much. Thank you for this opportunity. It was lovely speaking to you guys. I could share whatever I could. And thank you. You've been an amazing host. Thank you so much.